Hi there. Today we'll learn about the essential elements of a valid contract, meaning all those elements without which a contract will not be a legally binding contract. So let's read out what are those essential elements and then we'll discuss each individually. So the first essential element is two parties. There must be two parties. Second, there must be an agreement, that is offer and then its acceptance. Then it must have intention to create a legal relation. The parties must have contractual capacity. The parties must consent to form an agreement, and those consents should be free. The parties must have consideration, both the offerer plus the offeree. Then the object for which the contract is made should not be unlawful. The meaning of the contract should be certain. The contract is possible to perform. It is not something which cannot be performed. The contract is not void by the law, and any formality which is required by law must be completed in order to make it a valid contract. So now we know what are the essential elements. Now let's discuss them individually. So the first one is two parties. Obviously there must be two parties because I cannot make a contract with myself. Obviously I need one person with whom I can make the contract. So there must be two parties. Now with two parties, so the two parties can be a natural persons, or the parties can be any person having the legal existence, like any institution having the legal existence, such as companies, such as partnerships, cooperatives, universities. So they can be a natural person like us, or they can be the institutions which have legal existence. Second thing is this: the party who make the proposal is called the offerer, and the party who accepts the offer is called the offering. So the first most important thing which is essential for a valid contract is having two parties. Now let's move on to another. The other is agreement. Now when there are two parties must agree on some common thing. So there must be agreement, and as I show you earlier, that agreement is valid offer plus valid acceptance. So one party must make an offer and that other party must accept the offer. So there must be consent of mind. There must be agreement. Now there are two things. One is identical cross offers and the other is successive counter offers. Both are not the agreement because, let's say an example. A writes a letter to B proposing him to sell his car for $20,000. On the same day and time, B also wrote to A proposing to buy his car. So there are two identical cross offers or cross proposals, but there is no acceptance of any offer because A write to B that he is willing to sell and B write to A that he is willing to buy, but they do not consent to each other that he is willing to buy and he is willing to sell. They do not consent to each other's offers. They make offers individually. So these are the identical cross offers and they are not the contract. It's not the agreement. Similarly, the successive counter offers, those are not the agreement. Suppose I said to you, okay, I'm willing to sell my car for ₹20,000. You say, no, I will buy it for the 18,000. Then I say, no, I'll sell it to the 16,000. So we are just making the counter offers. None of us has accepted the offer. So till the offer is not accepted, it is not the agreement. And as such, when there is no agreement, there is no valid contract. Now, the third point is intention to create a legal relationship. So we studied earlier, or we read earlier, that the party must agree, and for that there must be two parties. Now both the parties must agree and they must have the intention to create a legal relation. Suppose me and my friend, we just agree to a common thing, but we don't intend to make a legal relation, then there will be no legal contract. This you can understand by seeing an example. See, A invited B to a dinner. A failed to come for the dinner. B reached to dinner place and spent money on the food for himself. Now B is not entitled to gain a compensation from A as it was a social arrangement where the parties do not intend to create a legal relation. So when A invited to B, he was not making any kind of offer, like he was making offer in general, but he was not intentionally want to make an contract. He was just inviting B and B just accepted his offer as a friend. He was not intending like, if I will come, then you have to feed me this and these meals, and if you don't feed me, I can sue you. No, because it was a social agreement. So in most social, domestic, moral, religious agreements, the usual presumption is that the parties do not intend to create the legal obligation, whereas in business agreement, the usual presumption is that the parties intend to create the legal obligation. So for a valid contract which can be enforced in law in court, it is necessary that the parties entering into an agreement have the intention to create the legal relationship. Now the fourth point is contractual capacity. This we will discuss in detail in the coming slides, but for now you can understand that contractual capacity means first that the person should be major. By major we mean that he should not be minor. So like in India, if you want to enter into any kind of legal contract, any valid contract, you must be 18 years of age. Second, you must be sound mind. By sound mind, what we mean is that you must not be lunatic, you are not under influence of any kind of alcohol, you are not under intoxication, and the third is you are not disqualified by law from contracting, such as alien enemies. This we'll discuss later in the coming slides. So just see an example. A minor, borrowed $100 from B. B cannot claim the repayment as the minor A is incompetent to enter into any contract by law. So this agreement is void. Now the next essential element is consent and free consent. So both the parties must consent with each other, and by consent what we mean is the party must agree on the same thing and in the same sense. So let's see an example. A has two cars, one black, one white. He offers to sell his black car to B. B accepts the offer thinking it of white car. So here there is no consent as both believe different, because A was willing to sell his black one and B is willing to buy his white one. So there is no consent to each other because both the parties are agreeing, but they are not agreeing on the same thing. So there must be consent, but consent must be on the same thing. So as such, no consent, no contract. Second, when there is a consent, that consent must be free. It means the consent is not caused by coercion, undue influence, fraud, misrepresentation, or mistake. This also we will discuss in detail in the coming forward slides. But for now, you can understand that the parties who are consenting with each other are consenting according to themselves. Like they are not under any kind of influence. Like if I am blackmailing A to have a contract with B, so here the A consent is not his own consent. He is just under influence of me blackmailing him. So there will be no contract. Now the next point is consideration and lawful object and consideration. So this also we'll discuss later on in detail in the coming slides. But for now you can understand that consideration means something which the offerer receives from the offeree in return for his offer. Suppose I sell my car to B for rupees 20,000. So I am receiving rupees 20,000, that is my consideration, and B is receiving the car, that is his consideration. So it may be in cash and kind. For me, I am getting cash. For him, he is getting car, that is in kind. Second, it may be in the form of some benefit, advantage, interest to one party and loss to other. So there is a benefit because I am getting the cash, and there is a benefit, he is getting the car, but at the same time I am losing my car, so that is loss to me, but I am getting cash, that is gain to me. So it can be any form. We can see it in any form, like it may be a benefit or it can be a loss to other party. Now the another thing is it may be an act or promise to do or abstain from doing something. It means it's not necessary that consideration should be in form of cash or kind. It can be an act, that is some activity, or it can be abstain from doing something, that is not to do any kind of activity. I'll give you one example. Suppose there is one boy who always throws a garbage on the street, and I don't like that. So I offer him that if you don't throw a garbage on the street, instead you put it in the garbage box, I'll give you rupees 500. The boy accepted. So the act of not throwing the garbage, that is the abstain from doing something, is my consideration, because I'm giving him 500, but in return what I'm getting that he's not throwing the garbage on the street. So this is a consideration for me. His act of not doing something is consideration for me. Now the next is, it may not be adequate. It means, what does contract act allow to you, or what does contract act want, is consideration. That consideration may not be adequate, so that is okay. For example, my car is value of rupees 50,000, but I am agreeing to sell it for rupees 10,000. I can do that. That is a valid consideration for me. I know it's not adequate, that selling a 50,000 thing for 10,000, but still there is a consideration. I'm okay. I'm willing to sell my car for 10,000. I'm getting rupees 10,000 as a consideration. So it is allowed. So the consideration must be there, but it need not be adequate. Now let's move on to lawful object and consideration. So any agreement for an unlawful object or the consideration is void. So the object of the agreement and consideration both should be lawful. This also we will cover in detail, but just read with me. Following are the circumstances when it will be considered unlawful: when it is forbidden by law, when it defeats the provision of any law, when it is fraudulent, when it involves injury to person or property of another, when it is immoral, when it is against public policy. Suppose I'll give you just one example, because we are going to discuss it in detail later on. So for now, just I'll be giving one example. Suppose I ask A that go and murder B. I will give you rupees 50,000. Is this a good thing? No. Is this lawful? No. Is the consideration lawful? No, because the object is murdering someone, which is obviously not allowed by any kind of law. And in consideration, what I'm getting? I'm asking someone to kill. So this is not a consideration. This is not a lawful consideration. So both the object of the contract and the consideration must be lawful. Now, another essential element is serenity of meaning. That is, the parties which are agreeing on the same thing in the same sense, they must agree on any agreement which has the certain meaning. Let's see an example. This will make the point clear. A agrees to pay B $500 for ultra modern decoration of his house. The agreement is void because the meaning of the term ultra modern is not certain. Obviously, for ultra modern, for A it may mean that stars are like blinking, the curtains are shining, and blah blah blah. And for B it may be something else. So the term of the agreement on which the parties are agreeing must have certain meaning. That is, what I understand is what you understand. It should not be like which can be inferred later on. Like, it should have definite meaning at the time we are agreeing on a contract. So the another essential element for a valid contract is possibility of performance. The terms of the agreement must be capable of performance physically as well as legally. Legally, I already gave you an example, like to go and murder someone. Obviously, I can't perform this contract, or anyone cannot perform this contract because it is illegal. An agreement to do an impossible act in itself is void. Obviously, to do any impossible act, we are agreeing on any act which is impossible to do. That is, there is no contract, there is no agreement, because that act cannot be done. For example, if A agrees to B to discover treasure by magic, so the agreement is void because the act is impossible to perform. No one can discover treasure by magic. It's just a story. It's just a fantasy, right? Fantasy. Okay, improve my English if I'm wrong. I know my English is not that good, but please cope with me. Let's stick to the meaning. Let's stick to the what I'm here to tell you. So the next one is, that is, agreements must not be declared void. Obviously, if any agreement which is prohibited by law, we cannot enter in those agreements. Well, in detail we'll discuss that what are those agreements which are declared by law as void. So those agreements cannot be entered. So there are some examples like agreements in restraint of trade and marriage, wagering agreement, illegal agreements, etc. We'll discuss them in the future slides. Now the last one is, that is compliance of legal formalities. So to make a valid contract, to make a contract which is enforceable by law, we have to follow the formalities of the law. For certain agreements, like it is necessary that they must be in writing. In general, oral contracts are also valid, but for certain contracts, they must be in writing. Example, insurance contract, contract based on natural law and affections, immovable property contract, they must be in writing. So we have to make them in writing if we want to make a valid contract. So summary of today's discussion is that every agreement to be enforceable by law must possess all these essential elements simultaneously. If any of the essential element is missing, then that agreement is not enforceable by law, and that does not create a legal contract. So thank you guys. If you have any questions, please message me, comment me. I'll try to solve your queries. And if you want to make some particular slide, particular presentation, then please message me. I'll be more than happy to help you. Thank you. Have a good day. Bye bye.